this morning is a session on oral advocacy, which I think is great to have the time to take and be able to practice these skills. We were talking before we came on the screen that it's a bit odd to do it by Zoom, but I think we'll make the best of it, and at least people are experienced with Zoom and know how to get around. So Odette is our speaker today. Odette Dempsey-Caputo is the staff lawyer at the Kamloops Legal Clinic. She's been a civil litigation lawyer for over 12 years, mostly on legal aid files and legal clinics. And now she's the staff lawyer at Kamloops, working with the advocates there and serving the community. So thank you. And I'll hand it over to you, Odette.
Thank you. I just want to thank everyone for coming. And yes, it would be a very different kind of presentation if we were in person. So hopefully, fingers crossed, next year. I know we said that last year, but fingers crossed, we'll be able to do things in person again. So I also just wanted to do a land acknowledgement. So I'm here in Kamloops on the unceded and ancestral territory of the Secwepemc Nation. I just wanted to acknowledge that. And I also use she, her pronouns. So I just wanted to start with a quote here, just from Martin Luther King Jr. I just want to commend all of you for being advocates. I really do think that it's an important area for access to justice. It's an area that's needed. And I know that sometimes it's a very thankless a job, and people don't necessarily acknowledge the, some of the hardness around it. But just Martin Luther King, it's not possible to be in favor of justice for some people, not be in favor of justice for all people. And I really feel that, these advocacy programs are really that. They are helping with justice for all people instead of it just being accessible to some, those with income or those that are maybe not part of marginalized populations. So I'm just going to start off with any kind of oral advocacy or pretty much anything when it comes to law. The number one rule is prepare. I cannot say that enough. There's no such thing as over preparing. And I know we all have busy schedules, but I think, if you start out right from the beginning, when you are dealing with, a file, and just take into consideration that you will be heading potentially to a hearing if you don't settle it, I think it will go a long ways. You'll be able to, be prepared, and then it won't be so much work when you get to that main stage of what's going on. So like I said, prepare, prepare, prepare. Just always be looking ahead about what might be coming, and know your case well. So this is a lot of information on one page. We're going to be going through it question by question. So don't feel like you have to write this all down. I did upload this, but these are kind of the questions to ask yourself. These are going to be the base of what you want to look at when you're going towards a hearing, whether it's a tribunal or whether it's in the court. Even when you're writing written submissions, these can also be very helpful. So you we're going to be looking at these questions. And, I have 8 here. There's always other questions you can ask, but I'm going to say these are the main 8 points that you're really going to want to go over and be thinking. And you can start this, like I said, right at the beginning. I mean, those first 2 questions, those are going to be the questions you ask right from the beginning when you first meet with your client. So I'm going to taking those questions into consideration, I just wanted to give you a little bit of a scenario. We'll do some exercises more towards the end, and I'm going to do this in more of an interactive situation. So, I'm going to read this out, and then as we go through these questions, I'm going to invite you guys to kind of tell me how you think this scenario, applying to those questions. Now, appreciate. If we were in person, I could have a whole package to give to you. So it's a little, less information than you might otherwise have, but we're hoping to be able to kind of work here. So we have Bo Peep has a dog named Buzz that likes to bark. And I've borrowed these scenarios from other presentations as well. So you will see similar names. Her downstairs neighbor Toy Story has complained about Buzz barking to Isabel's that should be Bo Peep's landlord, Andy. Bo Peep was just handed a 1-month eviction notice. Bo Peep wants to have use of the whole backyard. she is used to having the whole backyard, but Andy split it in half when Toy Story moved in. So that's kind of your scenario, kind of a simple scenario going forward. So I'm just going to explain these questions and then we'll kind of go back. So what does the client want to achieve? So that's one of the first things you kind of want to ask. What is the client really wanting to get out of this when they're going to the hearing or they're going to the tribunal? Now, you're going to ask this question at the beginning when you first meet with them, but that question can change, right? Right before that hearing. Things can evolve. We all know that tribunals, the residential tenancy branch isn't too bad for getting hearings. It's kind of a quicker process. But if you're looking at some of those other tribunals, like the security tribunal, if you're looking at human rights, takes years. Even if you're going to small claims, or if you're a family law advocate and you're dealing with family case conferences and stuff, those family management conferences, those are going to take a while. So these questions can change. So every time before you go to a hearing, or you're going to be presenting at a tribunal or before the court or helping your client with doing that, you're really going to want to ask those questions at the time. So clients will think that they've told you this question, but you have to dive more into it. You really kind of have to say, I'm sure you've all had those clients, they start back in 1975. You're trying to deal with a residential tenancy thing that happened a year ago. So you kind of got to pull them in. You got to get them redirected. And sometimes you just got to say to them, one of the best ways to get this is, if I had a magic wand and I could give you whatever you wanted on this, what would you want? Sometimes that's all you have to say. If you could have anything, at the residential tenancy branch, you could have them make any decision, what would it be? That can be sometimes the way. Then there's the other question. What are you hoping to achieve at the hearing? And the reason why I'm saying this is you guys are specialized in these areas of law. Your clients aren't, right? They're involved. It's their lives, but they don't really understand kind of what's going on. So what do you want to achieve at the hearing? You as an advocate. For example, my client, in family law, may want their children returned to them. When I was doing child protection, they might say, yep, if I had a magic wand, I would want my children back in my care. Now, as a lawyer, I know that that's not going to happen, right? They may be dealing still with severe, drug addiction. They may not have, put in the work that the social workers asked them to have those children returned. So my goal at the hearing may be to get them visitation, get them longer visitation, get them a plan that they can work towards so that their children can go back. When I've done mediations, I'm not going in to that mediation to get their children back. That's what the client wants. I'm going in there to get them the plan that they can start working on to get. So those are two very, very different questions. So what does the client want to achieve? And what are you hoping to achieve at the hearing? So just be really aware of that. And I think you can ask this throughout, ask at the beginning and ask it throughout, and especially just before the hearing. I'm family law. I know a lot of you guys wouldn't be doing it, but in family law, even in residential tenancy, well, I mean, some of the evidence, things can change like the night before if your client does something the night before. So sometimes this has to be asked, moments before the hearing, right? You might have had a client that was doing really great, and then, in family law, and then they go on a big drinking binge, or they crashed or burned or they got arrested. Now you might have been able to get their children back, but now that's not what you're doing. So that's just something to be aware of, that these can constantly change. So just going back to the scenario, if anyone wants to take it, I'm going to ask the first question. What do you think the client wants to achieve in this scenario? If anyone wants to kind of answer that. So kind of read over the scenario. I'll give you a minute. Anyone who wants to just hop on and you can talk, unmute yourself and talk.
Some people put comments in chat as well.
Sure. I'll open up the chat so I can see it. Celia, would you like to answer?
She wants to stay in her apartment.
Yes. Right? What might be another thing that she might want?
The whole backyard.
Yeah, the whole backyard,
Sorry.
right?
Yeah.
So, so that's what your client's going to want. So what do you think you as an advocate might be trying to achieve for them? Now, it could be exactly the same. It might not be.
Someone is saying they would like the eviction notice vacated.
Yeah. Cancel the eviction notice. You might not be able to do that backyard thing for them, right? That, you're going to look at the tenancy agreement. Maybe it was clear in the tenancy agreement that they didn't have access to the backyard. So that might be where they have the two goals and you have the one goal. That doesn't mean you might not pursue that other goal. It's just that that's what you're asking for to achieve. There's a good comment. Natasha said, get them to compromise and share the space. That is a great compensation. Jen, good point. Compensation for loss of the yard. If it was, they did have it before and they were allowed to do that. You're right. Now they might be able to get that compensation because they have lost that yard. So the next question you're going to ask, what are the issues? And I put on here weakest and strongest, and there's going to be a reason why, right? You really want to identify what are the issues. Now, in our scenario, we're not going to have a lot, but you might have different issues that are coming up. So there might be an issue might be that they're fighting with each other, right? The tenants are yelling at each other and they're screaming. You might have an issue of around, in family law, we might have a mother-in-law that's getting involved. So that might be an issue. You kind of want to write down all these things. So what are the issues? You're going to look at the law and stuff, and we'll get into that. And the issues might come out of that. And you kind of want to identify what are your strongest issues and what are your weakest issues. So what are going to be your strongest kind of arguments to work around these issues and what are going to be your weakest? What are the more important ones? What are the ones that are less important? So you kind of want to, kind of look through them and figure out what's weak, what's strong, what is more important, what is less important, and just keep that in mind. So I'm going to go back to the scenario. I know it's kind of a short scenario. What are the issues here? What do you think might, so now we have Bo Peep has taken videos of the Toy Story in the backyard. So she just handed a 1 month eviction notice. Bo Peep wants to have use of the whole yard. She used to have the whole backyard, but Andy split it in half when Toy Story moved in. Bo Peep yells at Toy Story whenever she's in the backyard. And Bo Peep has also taken videos of Toy Story in the backyard. Does anyone want to take a guess at what the issues might be there?
So I would assume the strongest is the eviction notice, and we don't know exactly why, but I think it has something to do with noise or disturbance of another occupant. But also I can tell there's a lot of conflict, so this is also an ongoing issue.
Yeah, and I can see a lot of people writing in the chat, loss of quiet enjoyment, right? That's what you're looking at. There was some more up here. The dog is barking. There's an eviction notice, use of the backyard, right of piece of enjoyment. So those are kind of things that you're going to be dealing with, right? Those are kind of the issues that you're going to be dealing with, and talking about like changes that might happen right beforehand. So let's say you had this scenario and right before the hearing, the police get called, they get into a huge fight and the police get called. So now all of a sudden you're dealing with, that's going to come up, even though you're supposed to get your evidence in a week or 2 weeks before, but it's intensely brand, they're going to listen to that because now it wasn't evidence you had before. It just because they have evidence deadline doesn't mean that issues still can't come up or kind of what you're looking for can't change, because if they didn't have the opportunity to put the evidence in because it didn't exist before, then they're going to allow the evidence in. So there's always exceptions to those rules as well. But like, let's say they got into a big fight, the two tenants, and now the police have been called. So that's just kind of example of how things might change. So then, of course, and you're going to probably do this really early on, and a lot of you guys are very familiar about this, but you're always going to look, what is a law that applies? So the first thing you're always going to do when it comes to what is a law that applies in oral advocacy is what statutes apply. You're going to want to have that available. You're going to want to go through that statute that applies and take out those sections. I don't know how many times I've made that mistake. I just assume the judge knows, or, it's common, in family law. And then they ask you about some obscure section of the Family Law Act that all of us know, but I can't remember the section off the top of my head, because they might not be as familiar with it. You might get someone who's new, is the new decision maker, whether it's a tribunal member or it's a judge. They might not be familiar with this kind of thing. So you can have very, very experienced ones where you don't have to worry about that, but you want to have the statutes. I actually put it on a different piece of paper and I print that out and I have them in front of me so that if I do need to call on them, I can look down that paper and be like, this is the section. I don't necessarily put that right into my written argument. I may refer to it in my written argument if it's really pertinent to me doing that. Or my oral argument, because I write it down. So I'm not talking about a written argument I hand up. I'm talking about one that I'm saying. I might put it in there, but I also want these other papers so that if they ask me any questions about the statute or the section, I have it there. I have it available. And then there's case law. So you have case law. We come from, a legal system where we rely on precedents. So whatever a judge or a tribunal member, not all tribunals do this, but it does offer evidence towards it. Residential tenancy branches are bound by previous tribunals' decisions, but they are bound by what judges have said. So they do have to be careful about that. So, I mean, you might have, a Supreme Court decision where it's been judicially reviewed and the Supreme Court said, guess what? You guys got it wrong. And this is the law around quiet enjoyment. So it's always handy to have those, I'm going to put a little bit know your audience. And I didn't put this on a slide, but I should have emphasized this a little bit more, but know your audience. So there's going to be some tribunal members and some tribunals where you're not going to want to get into depth in case law. And then there's going to be other ones that very heavily depend on it. Human Rights Tribunal heavily depends on, human rights decisions and that case law. The residential tenancy branch, you can bring them up. You guys, I mean, if you've done a lot of them, you'll know there's different decision makers. Some of them want more of that, some of them want less. You kind of have to feel it out. And that's why it's handy to have it there and kind of know them. And one of the reasons why you really want to do this is because you need to figure out what are your key legal principles or legal arguments. So you need to know, what do I need to meet? So if we have that quiet enjoyment, there's those policies that the residential tenancy branch has. You can look at them and say, okay, this is what they have to meet. Talk about, and I know they've kind of changed this, the reno evictions. So when you get evicted for renovations, there was a time where you didn't need to have permits. Now you need to have the permits all lined up and ready to go, right? If you didn't know that, then you don't know to argue that. You don't know to say, we haven't seen any of these permits. The landlords offered no evidence that they received these permits. So even though there's doing these renovations, they really haven't met what they needed to do to evict the tenant. Right? So that's why it's really important. So you're going to figure out what the statutes are, figure out what the case law is, figure out what the test is. That's what we say as lawyers. What's the test that you have to meet? It might be, so-and-so, it says this, and then you have to meet these 3 criteria, right? You need the proper eviction notice. You need, to have the permits in place. It needs to be something that's enough to move out, that the tenant can't stay in the place. It can't be just changing a sink. Changing a bathroom. If there's 2 bathrooms, then they don't need to evict them if they can use the other bathroom. So that's the kind of thing you need to lay these down, because this is going to be the foundation of your submissions and what you're going to say to the decision maker. So this is really important. Like I said, you can do this at the beginning when you first met them. You're going to kind of work through it out, but it's really, really important to know this well when you get before your decision maker. And be prepared for them to kind of throw you off. So, and ask about other things. So it is really good to kind of know that statute, take time, just read through the Residential Tenancy Act if you need to, or read through the case just to kind of refresh your mind, even if you've done it quite a bit. So then the other question you're going to ask is, what are the key points do you need to prove? Okay, so we have the law that you need to prove. But the key point might be, do they have the permits, right? I actually recommend that you have a chart and you're going to put the key points on one side. Okay, these are the things I need to prove. And then what's your evidence? So do you have the evidence to prove it on the other side? And then you have a nice chart. So you have the point you need to prove and what's the evidence you're going to need to use to prove that point. And then you're going to go down. And that's going to give you a really good sense of what you need to say, right? And how you need to prove it. Because every time you make one of those key points, you're going to need to refer to the evidence. You need to prove that key point. So that's how you're going to kind of do it. It's almost like I hate to say pyramid, but it's kind of like a pyramid, right? You have your point and then you branch out, right? That's what you're going to do. You have your point and then you branch out with that evidence. And I'm sure you guys are all aware of this, but evidence comes in all types of forms. I know we struggle with our clients getting us the evidence. I don't know if you guys do. I have a lot of issues. The clients will give it to me in all kinds of formats I can read, formats I can't read. It can be signy, it can be big, but it can be photos, it can be videos, it can be letters and emails, it can be text messages. I am going to make this point, be very aware of what your decision makers, the tribunal or the court requires for your evidence. You'll probably notice a lot of people just get a type letter and they say it's from some neighbor. Well, who is this neighbor? How do we know they didn't just type this letter, right? Is it signed? Really, I often make that argument in residential tenancy hearings where I'll actually say, how do we know this neighbor? Like really the proper evidence. You want the evidence in the best form, right? Not a letter that's signed. You want that from the actual person so you can call them up. Now, it's a little bit different when it's a doctor. Interesting enough, getting doctor's evidence where it's just a letter signed by a doctor can be much more acceptable than just having your neighbor sign a letter. But just kind of be aware of that. So when you come to the evidence, it can come in all kinds of forms. You need to read your tribunal or hearing the way they accept evidence. Sorry, does someone have a question? But someone had a good point here too. I just want to put wording of the lease agreement and addendums may apply. So you need to look at those addendums, look at the rules of your tribunal and the court. Rules change, so be aware of that too. If it's been an area that you haven't worked in for a while, go back and look because they change all the time. Little things can change, but you just want to make sure you're getting that evidence in the best possible form. I know that I've talked about this sworn documents. I like to have it in stat decks, right? I think that, getting a stat deck, which is similar to an affidavit, statutory declaration just means that it's a sworn document like an affidavit, but there's not an actual court hearing. So you're not like in the BC Supreme Court or, the provincial court, RTB, it's more of a statutory declaration. I know some of you are notaries. You can also, if you have a supervising lawyer, can sign on that, getting that kind of evidence in. I also find that the sworn documents are really good for outlining your evidence and getting them in a really easy format for your decision maker to read. It's also really handy, and we're going to get into this when you're referring back to your evidence when you're making your arguments. If you can say, oh, the affidavit of my client, page, 6, paragraph 22, exhibit, and take them there, and then you'd be like, oh, and it's exhibit A, which is on page 10, and then it really makes it easy for the decision maker. It gets that evidence out. When you just pile, RTB, I know you can just submit all your evidence. It can be very hard for the tribunal member to look at each piece of evidence because they have to open up each individual piece. But if you have it attached to a stat deck, then you have it right there. They're only opening one document. So it can be very helpful that way. It's a really good way to organize. It also forces you to think about these other things that we were talking about and kind of have that laid out when you've put it in a statutory declaration form, because it forces you to have to ask these questions so that your statutory declaration is in a really good format. I know a lot of people submit their evidence when they first submit to the tribunals. I like to wait a little longer because sometimes when you're first submitting, to an RTB tribunal, when you're first submitting the notice of dispute of an eviction, you might not have all the evidence. You might not be aware of what all the evidence is. You might not be aware exactly what's going on. Our clients, always be aware that what your clients tells you, they're the hero of their own story, right? Whatever they're telling you, they're giving you the best side of their story. They're not necessarily going to tell you everything. They're not necessarily going to say it in the light. You'll find that when you reach out to people, that they will actually say to you that, you know, all of a sudden the other side comes up with this whole story and then you're having to deal with it. So kind of waiting sometimes for that, for kind of that time to kind of wait it. And so don't feel like you have to rush, right? There's timelines are to be 2 weeks before, 14 days before the hearing. It doesn't hurt if your hearing's going to be 6 months down. A lot of things can happen. Remember when I talked to, let's say I got in a fight and now you have this police officer, let's say that happened, you know, 3 weeks beforehand. Well, now you have time to put that in your stat deck and deal with that issue, right? Now it's a new issue. You need to deal with it. Like I have it in here, check how you have to upload the evidence depending on the different hearings or how you need to present the evidence. A lot of things, even in court right now, are being done by phone. You're going to need to be aware of what type it is. Is it going to be MS Teams? Is it going to be by the phone? How do you send it to the other side? Is sending it via email okay? Or do you have to like register mail it? Because you can do all of this work. And if you don't give it to the other side appropriately or forget to give it to the other side, it will be excluded evidence. And then, you know, it's not going to be very useful for you. Just, does anyone have any questions before I continue?
There's a comment in the chat that RTV prefers witness statements in affidavit.
Yeah, I find that too. And that's what I'm talking about, that statutory declaration. And I agree, even the witness statements, I think it's really good. I mean, you can have them attend in person as well. One of the things that's kind of nice about a statutory declaration, even with witnesses, is one of the things that you're doing there is you have a little more control about what evidence is getting out. I might like, you know, we all have those clients or witnesses that kind of go off on tangents. By submitting it that way, I always try to do the most of the talking. The less my client has to talk or the witnesses have to talk, the better it is. You know, they'll go start talking about that thing in 1975 and then they just annoy the decision maker, you know, or they're wasting time and then you run out of time and you can't get the information you need before them. Or they say something that really isn't relevant, but is detrimental to them, right? Maybe not, doesn't put them in a good light. I mean, it's like as much as we'd like to think that, you know, if your client comes across as being the unreasonable one and kind of the jerk in the situation, it's much harder to kind of get over that hurdle and get the decision maker kind of on your side, per se. You know, almost every decision maker, whether it's a tribunal or it's in the court system, you gain a lot of favor by your client being the reasonable one, right? And I'm going to put this out there, even though it's not really around oral advocacy. When you talk to your clients, tell them, you know, when you put something in writing in a text message or you put something in writing in an email, you need to think about that being before that decision maker. So when you're doing something in writing and even verbally, when you're saying something, you need to be really aware that when you do that, that could end up before a judge. And you really want that to be the way the judge is looking at you. People say stuff in anger, but when it's written down, it's much easier to prove on the other side. You know, in family law, that often happens if you're the, you know, the parent that's constantly blocking access, constantly, you know, making everything difficult for the other side. You're just not going to get, you know, it's going to be used against you in the court. So that is kind of a thing that's good to say to your client, just so you're kind of aware of that. Kind of the next thing, this is a more complex kind of idea. So there's two things in case law you're kind of dealing with. There's the theory and the theme. So first you're going to deal with what is the theory of your case. This is kind of the meats and bones of your case. You know, it's a detailed and accurate story of what occurred. Okay. It's how you tell the story of your side of the matter. And it should be in a single paragraph. So this is really difficult to do. And you may write it out and then rewrite it and then rewrite it, because you don't want it to be a page long. You want something that you can summarize really what the theory of your case is. It can be a single paragraph, couple of sentences. It's going to set out the facts and it's going to set out the legal principles in a way that justifies the outcome you want. So it's got to be in a way that says to the decision maker, this is what's going on. This is why you should decide in our favor. I'm trying to think of a good example of this, but it's just something to be really aware of. This is probably going to take a lot more work than you think. Sometimes it's really obvious. A lot of times it's not. I assume advocates are better at this, but lawyers are notorious for talking forever and going on and on and on. So it can be very, like this is something that a lot of lawyers really fail at, is being able to get that kind of conciseness of what their case is about. It might be simply, I had actually, I'm going to go to theme and then I'll go give you this example, because after this is kind of the theme. So what is a good case theory? It's logical, right? Very logical. It's simple. So, I mean, in logical, what we mean is it's not something that's way out there, right? It's not something that's hard for someone to believe. It's something that's easy. You don't have to do a lot of evidence to support what you're saying, right? You don't have to try to convince someone. It's logical. It's simple. So it's short, it's simple, it's clear. You don't need to use $10 words, okay? You can just keep it simple. I always say, try to aim for a grade 6, grade 9 level of when you're doing this. It has to be plausible. It has to be understandable. All of these kind of seem the same, and it seems really, it seems like common sense. When I'm going to say it has to have common sense, it seems like common sense that you do this, but sometimes we get so wrapped up in our file or in our matter, we have trouble, seeing these kinds of things. It's a really good idea to take your theory and kind of pass it by someone else too, that's in kind of your bubble of confidentiality, to see if it makes sense to them. It's the framework for your facts, right? And it addresses the legal elements of the claim. So if your claim is, they didn't have permits, then you're going to put that in there, right? That's that legal element. They didn't, yes, they said they were evicting, but they didn't even have permits. So you kind of want to address that all. And it seems like a lot to have in like just a few sentences, but it can be done and it will serve you well. So I'm going to kind of go back to here, and I'll give you a few minutes to kind of think this over. So what I'd like you to do is kind of look at this scenario, and I'm going to give you about 3 minutes to kind of think about it and just write it down. What do you think would be your theory of the case in this one? If you don't, I'll actually give you 5 minutes, because if you need to look up case law, feel free to do so, or look up the law. Most of you should know it. So I'll just give you a few moments to kind of go over that, and kind of look of figuring out what you think the theory would be, and then I'll ask people to talk about it. Oh yes, and there's a really good point here, and to tell your client. Jesse says, I tell the clients, the longer you speak, the less likely we are to win. I've said that to clients too. It's true, right? And we're going to go over that a little bit later on, but yeah, clients, the more they talk, the more stuff can be used against them. And if you have any questions while we're waiting, feel free to pop on and ask them as well. Okay. If everyone is ready, does anyone want to, and we can get a couple of answers from this. So you can write it out in the chat, or you can just pop on and speak. But does anyone have what they think the theory would be for this file? And I should tell you, you can elaborate on some facts as well if you need to.
I'll pipe in.
Thank you.
I think that a couple of things I would want to point out is that the 1 month eviction notice I don't know if I'm on the right track. So the 1 month eviction notice was issued. We're assuming that it was for infringing upon the other tenants' quiet enjoyment. But I think that I would want to point out that, yes, my tenant's dog is barking. However, my tenant is allowed to have the dog, as, I'm going to assume once again that this was allowed at move-in on the tenancy agreement. So on that aspect, she's not doing anything wrong. She's allowed to have the dog. What I think is happening, what I think is wrong on both sides is that one of them is videotaping the other, That's not okay. And then another one is shouting at the other ones. So that's not okay either. So I would really be trying to push for compromise on both parts, because I do believe that both sides have played a part in this eviction notice being issued in the first place.
That's great. And I actually want to point out something, really kind of pointed out, is that assuming. That's something that, you know, it's really important in any kind of area of law, is just never assuming stuff. In this case, I'm allowing you guys to assume. Like I said, if we were in person, I would have had a whole package with evidence and everything. the whole 1 month notice, eviction notice. You know, one of the things that you could say in a very short period, like say, let's say it is the dog, is you could be, you know, you could say, you know, section, you know, I can't think of the right section of the RTA. You know, it's around quiet enjoyment, and I can't remember exactly the words, but anyways, you could point out that, you know, the client's dog barking is to be expected because dogs will bark. The dog was allowed, and it's not unreasonably disturbing the other tenants, right? So that would be a really kind of quick scenario, not unreasonably, and that the other tenant is being hypersensitive, right? That could be kind of your theme. Oh, here's one written out. Toy has been purposely provoking the dog, and Bo Peep was taking video to have a record of what is happening. Bo Peep had a quiet tendency up until Toy Story moved in, and Bo Peep has been yelling at Toy Story to leave her dog alone. So you kind of want to just have a paragraph. You're going to use this later on in your submissions, right? So then after that, you're going to have your theme, okay? And I know they seem different, but the theme is really the moral of the story. Oh, motivates the decision maker to action and shows why this desired results is deserved and necessary. And it also sets the tone of your client's case. So I'm going to, I know that I'm just using a child protection case because I had one that was really good this way. One of the things in child protection is that when children are removed, the ministry is supposed to work towards reuniting the children with their parents. In this case, I actually felt, I always call it almost my Hail Mary case. I thought there was no way I was going to win this. It was 10-day trial. It was, you know, I had, I think, 13 big plastic containers of evidence. And I'm talking emails and stuff. I mean, it's impossible to get through all that. And right up to the day before we started the trial, I was still reading through it all. Like, there was just so much, there's no way. And my theory was that they had been, the ministry had no intention of ever returning these kids. So there's a test, right, of why they should get returned. But my theme was, I should say, was that that the ministry never intended to return these children, that they had just decided that they were removing these children and that they would never go back. The day before, I actually found evidence that proved my theory and theme. And I found an email from one person in the organization to another saying that they should never allow these children to be returned 1 week after the children were removed. We're not talking about a case where children were being severely abused. We're not talking about that. It was very kind of minimal about what was going on in the home. And that email, I to this day still believe, won me that case. If I hadn't had a theory and a theme prepared, it wouldn't have worked as well, right? I was able to establish the law, put it all into a paragraph, kind of put in why should they return, and then the theme was that the ministry was being unreasonable. That was the theme. They were being unreasonable during visits. You know, one of the things that even came out in the theme that I was able to build on was when they had visits, it was a 10 by 10 room, and there was like numerous kids and very little toys in there. It was the same room 2 times a week. Think about kids, right? They're going to get bored. And the person that was supervising, writing down notes when they were visiting, was constantly criticizing these parents because the kids were acting out, right? And of course they're acting out. They're bored. They wouldn't even allow them to go into like a park or anything nearby. And one of the things the supervisor said when I questioned about, what were they doing wrong? Well, they were using timeouts. Okay, they're using timeouts for their kids in this room. What do you propose they do? Well, time ins. And I'm like, well, what's a time in? And they're like, well, time in means you're next to the child and, you're kind of there with them. And I was like, it's a 10 by 10 room. Right. And so throughout, whenever I was giving oral submissions, I would say timeout/time in to show the unreasonableness of that scenario where they were criticizing these parents and not letting them get further visits or leave the room because they were using timeouts. It was just a word. It was literally going to be the same way. It was just the parents used the term timeout and the supervisor was using the term time in. Really not a child protection, but that's kind of where your theme, because then you can kind of build on that theme. And it really helped the judge to see how unreasonable they were being when it came to these parents and these children. And it was really laid out in that judge's decision at the end of it, and it all started with just like the theme that they were never going to return these children. And the law was that they should be working towards returning these children. So that's why it's kind of important to have a theme. And I really do think that it helps. You kind of want to look at this, and there's lots of materials out there if you want to look into. There's some really good books to kind of develop more into it. These kind of like bigger concepts when it comes to doing oral advocacy and kind of preparing for these hearings, these kind of theories and these themes. But, that's kind of what you're looking at. So I'm going to say organized reference. I just want to go back to kind of the story scenario. The theme might be that the upstairs neighbor is just being unreasonable, or whatever the neighbor was being unreasonable. The other tenant is just being unreasonable. The other tenant just doesn't want to be disturbed at all, that they don't care about how much noise it is. And you might have evidence of them getting mad when, someone turns their TV on or something like that. That could be your theme. Your theme could be that the other tenant is being unreasonable, or it could be, pardon?
Sorry, there's a couple there sort of like that in the chat.
Sorry, I'm just trying to.
Sorry, didn't mean to stop you, but.
No. My chat kind of disappeared. Trying to figure out what the last one we talked about.
So there's one that.
I'd probably bring up estoppel as the dog was allowed to have a full yard, and now that privilege has been removed and was not agreed upon when the tenancy started. I think the case theory is logical and plausible. That is a very plausible one. That's a good scenario to go on. I think Jen had mentioned too about getting compensation for it. You've now had something removed. Somebody said where I'm stuck is that if a tenant was doing things that are problematic, the tenant needs to be cautioned to stop in that period between now and the hearing. That is true. That can also be your theme. I've had that theme as well, in that theory where, oh, look, yeah, they were horrible then, but look how great they've been the last year. We really should, that can be your theme. Your theme can be, yeah, they admit they were wrong. They made really bad choices back then. Not so easy with the RTV. And the RTV is not as forgiving.
Someone was saying essentially what you were saying, that Tori's been purposely provoking the dog while Peep was taking video to have a record of what is happening. And Bo Peep had a quiet tendency until Tori moved in. And she's just been yelling at him to leave her dog alone.
Yeah. And so this one even continue too. The best argument may be the behavior was stopped, not necessarily that it was provoked. It really depends on the arbitrator. It does. And that's something you really need to, that's when you really kind of need to, a lot of it is going to be instinctual, and with experience, you'll learn this. The decision maker, you're going to get a sense of your decision makers. You'll get used to the decision makers. One of the benefits of being here in Kamloops is we appear before the same judges. You do a bit in Vancouver as well. We just have, we tend to appear more often before the same judge. I got to a point where I could tell you which judge was going to get upset with what part of my case. I could look at my client and say, we have this judge and he's not going to like this, and this of our case, but he's going to love this and this. And then the other judge, it might be completely different things. You'll really get to kind of know. You can tell, and I'm going to start talking about that later on too, is keeping an eye on your decision maker. Harder to do when it's by phone, but you can still get a sense of what they're saying, what kind of questions they're asking, and hearing their voice. But yeah, it is going to kind of depend. And then there's another one here. Quiet enjoyment, disturbing neighbors, breaking rules, and tenancy agreement. Tenant is a good tenant, pays rent on time. The dog is young and needs space to run. Plan to take the dog to the park every day. Also, a friend will take the dog to the park in the late afternoon. Also, doggy daycare is near the tenant has applied to and was accepted. That is a great kind of thing to put out there, right? And that's kind of like, another one says, I have a few arbitrators who I know right from the beginning how the arbitration will go. That is very common, especially I think in the residential tenancy branch, for sure. I mean, and that's like judges as well. You get a sense of what they like. You know, they stopped telling lawyers what judge they were going to have a lot of time in ahead of time, because what was happening is what we call judge shopping, where they would know who the judge was. So then they would adjourn it. So they would get a different judge if they didn't like the judge, try to get it adjourned. So, I mean, yeah, and that comes with experience. You'll try things out and you'll realize it's not as good, but yeah, like really your theme and theory, as long as it's based in your facts and on the law, you can't really go wrong with it. You know, you'll find that some work better than others, but really just having something that you can keep driving into the person. You know, you think about movies that you've watched, they all have a theme. They all have like an outcome. You might not remember all the details that came between the beginning and the end, but you'll remember the theme. You'll remember kind of the theory of what was going on in the movie. So what it does is it allows you to keep coming back. You know, your theme, if you're really driving your theme in and your theme's tied to your theory, that paragraph that you have that kind of summarizes everything, you can keep using your theme to drive back that theory, right? And it just really, then it will start to stick in the judge's head or the decision maker's head, and then they'll really come on side with you. And then when they go to make that decision, they have to, even if they make the decision against you, they have to get their mind around that before they can kind of come around. Always, so someone said, is there room in this approach for in the alternative arguments? I always use in the alternative arguments. So you always, I don't know how many times I've used them. You're always going to have your main argument that you're going to drive the most, but you are going to have those alternatives. So you might have two paragraphs, the one with the first one and the one in the alternative. Not uncommon to do at all. Smart thinking, that's a good comment to make, and it's always a good one to have. You can also kind of keep your in alternative. I usually always say them and present them, but you can always have them on the side if things start to go a certain direction. If you start sensing the decision makers going a certain way, that you can pull out that in alternative. So if it's going to be kind of really to your detriment to bring up in the alternative, usually it is. That's why you're not doing it as a main one. There's a little bit of not thing, you can keep that to the side and kind of have those arguments there. I do that. I will have, you know, everything written out for my arguments, and then I have another page with alternative arguments when things start going a certain direction, or I'll have it at the end where I can flip to the page, right? You know, and yeah, so that's a really, really good comment. Thank you, Simon, for that comment. So organization. So when I'm talking about prepare, we brought this up a little bit with stat decks. Organization is huge. The easier and simpler you make it for your decision maker, the easier it is for them to buy into your theory and your theme, right? Because really, if you're the advocate that's flipping pages back and forth and confused about where you're going, it all gets muddled in the decision maker's mind. So then you've lost kind of that momentum of your theme and your theory. So you really want to organize your documents. So you need to take time to think about this. And I know this seems more like not on an oral advocacy. It really is. It's when you're given written submissions, it's easy to take the time to refer to different things or have them just look over the documents. But when you're giving oral arguments, there's just not that much time. It's not that the judge can go and flip back and forth, the decision maker can. So you want to really think of, how can I do this in a helpful way? So how can I do this in a way that's simple, it's clear, it's concise, and it's easy to find, right? I recommend you always list your documents. Number your pages. That's another thing. Number your pages. That makes it extremely helpful. Saying Exhibit A isn't very helpful if it's a 50-page document. Where's Exhibit A in that 50 pages? But if you can say, turn to Exhibit A at page 30, that's so quick, so quick. They're not searching for it. They're not like thumbing through it. You may be able to do that easily because you know how you set up your documents. They can't. We use tabs. So if it is an in-person thing, or if you're able to kind of give a binder, binders are huge. Whatever you give to your decision maker, have a copy of that in front of you so that when you're referring to your documents, you can, telling the decision maker to do that, you're going to want to do that in your documents as well. So you're looking at the same thing as them. And so I don't know how many times I've had, like even in RTV, where the other side hasn't numbered their pages, but we have, and the other side actually ends up using your documents because yours are easier, right? You want that happening. You want them to start, you want the decision maker to be using your documents, and you want the other side to end up having to use your documents. It can be huge, taking this time to just make it, you want to keep it simple and make it as easy as possible for the decision maker. If they're having to flip through your documents that are super easy, they're also going to see the ones that are really good for you too, right? It's going to, bring it up into their mind. We use a lot of binders. I know that a lot of tribunals right now, especially, are not in person or not able to submit a binder. We use the tabs, list your documents, have a table of contents, have a way where they can find the documents. That's where I was saying that statutory declaration is really, really helpful, because a statutory declaration allows you to organize your documents. Then you have it in a chronological order. You have your documents, you have your theme and your theory set out in there as well. Statutory declarations do have to be fact-based, not argument-based, but you can, you have your facts right there. Your client's not having to talk, and your documents right there. So you can say, as my, client stated at paragraph 4 of the statutory declaration, this is what happened. It helps you organize your client's thoughts as well. That's why I'm going to go back to that statutory declaration. I know I'm really pushing them, but our clients, when I was saying it also helps them not say too much. Our clients often have difficulty explaining what's going on. They have difficulty. They deal with all kinds of, there's mental health issues. There's, their lives are in shambles. They may not have a place to sleep or stay. So they have a lot going on. And it can be very hard for them to express what's going on in a chronological way, or in a simple way that makes sense. You might be able to understand it because you've talked to them a lot. So when they're talking about, you take the story about the dog barking, if they start talking about a dog that they had when they first moved in, you might understand why they're talking about that dog, because that dog might prove that they've had the dogs all forever. It might not be as helpful for the decision maker, right? The decision maker is like, what dog are we talking about now? They might not make it clear that it's a different dog. They might use, it is just, statutory declarations are a really good way to organize stuff and organize your documents. And you're going to have them A, B, C, D, E, and it also makes it more clear. But I mean, just even having it set out in a way, I know that I've seen advocates that they may not have a statutory declaration, but when they're uploading it to the RTB site, they will put Exhibit A, Exhibit B, Exhibit C. Not so much, this is kind of an alternative way of doing it, but it was helpful in the way that even though it's not an exhibit to a statutory declaration, it does allow you to refer to something. So instead of saying, oh, that photo, right? That photo. Well, if you have uploaded 3 photos, which photo are you talking about? Now you're asking the photo of the house. Well, now they're having to flip through to figure out which photo. They have to look at all 3 of them to find the one of the house. But if you called that photo Exhibit A, or, evidence 1, or however you want to indicate it, now they know what photo. It's easy for them to get it there. It's easy for them to find where it is. Also, make sure, you're talking about organizing your documents are easy to see. They're easy to read. Our clients are notorious. I mean, My clients constantly take pictures off of cell phones and send it to us. Some are better quality, some are not. Some are really hard to read. Some of them you have to zoom in and you can't even read it. Sometimes when you photocopied or scanned it in, it's gotten fuzzier. You want to make it sure that it's in a way that you're not having to, the decision maker is not like squinting. There's all kinds of things that you can use to kind of get it in a format that's easy. If you're going to have, video, it needs to be in a video format that the decision maker can find or use. Are you going to be giving it to them on a stick drive? Is it going to be on a, burned kind of CD? How are you giving them these documents and how is it being organized? That's an easy way for the decision maker to make. Now, if you're in, not that you would need to, but if you're in an in-person one, you want to make sure that there's like a TV if you need a TV there. If you're showing something or if you're doing a computer, you really need to reach out to these tribunals to make sure that even your documents can be presented in the right way. Unfortunately, with COVID, I'm finding these things are changing a lot. So be aware of that. There's different kind of approaches and rules when it comes to evidence right now. I have a payment hearing coming up tomorrow, and generally what I would have done is prepared a nice little binder and handed it up to the judge. Some of the things we were able to drop off the registry. This particular one we tried to, and they're like, no, we don't want it. So things are changing constantly. Sometimes you have to submit it early. Sometimes, if it's in person, you can show up and just hand it up. But just be aware, anything you give to the decision maker, you should be giving to the other side. Organizing documents. Another thing, you're talking about this backyard, having them make a diagram, is a document you can have created that helps organize things to help make it easier for the decision maker. You can have pictures, but even a diagram. I had one that was about a strata and a parking spot. And we actually had a copy of all the parking spots at the strata. And I actually had the client draw where they had to walk to get to their place with their disability right on the parking lot map. Just because that gives the decision maker, it's a way to organize your documents that makes it easy for them. Now, am I going to put that in amongst a whole pile of photos? No, I'm going to make sure that's a separate document. That's a separate document that they know. It's not going to be pictures of a dog in the middle of pictures of a dog, right? So you need to think, organizing your documents. Also, how are you presenting your argument? It's really easy for the decision maker if the way you're presenting your argument kind of flows with the way your documents are being presented. That's not always possible, but it is a good, easy way to kind of do it so that it's kind of in a chronological order. Just think, what would make this easy for me if this is the first time I ever see, because the decision maker's never seen this file, or if they've had less experience with it than you, right? So you want to make it as easy as possible for them to figure out what's going on and why they should buy into your theory and theme. So is there any kind of questions around documents before I continue? I tend to talk fast, so if I do, just put it in the comments and tell me to slow down. Move on to the next kind of thing. So preparing your case, it's really, really important to have a good way to prepare your case. Oops, sorry. I'm just trying to move this thing here out of the way because it's kind of blocking Okay, so whenever you're preparing your case, like I said, organize in binders if possible. Your documents, even if it's kind of like a virtual one where you're kind of doing that, where you can have the table of contents and then have the documents behind it, document 1, document 2. Another thing is, prepare your questions for your witness and your client. You want to have all those questions prepared ahead of time. Things change when you're there. So you can always leave space. If you write a question, don't have it all like crunched together. Leave a lot of space. The reason why I say leave space is then you can make changes, you can write in it. You're going to prepare those questions. That also helps you kind of figure out how to go through your case and how you're going to present it. So you're going to have questions for your client as well as for those witnesses. Think about and then you're going to do the same for cross-examined questions for the other side. One of the things I recommend when you're doing cross-examination questions and you're kind of organizing that as you're preparing for kind of an oral hearing or oral advocacy is think about, so cross-examination, you might kind of move things around a little bit more. So you're not going to be so chronological. One of the things to do when you're cross-examining the other side or asking questions is do easy questions first. Everyone has their own style, but when you're asking questions on the other side, you kind of want to get them to like get comfortable with you, right? You're asking easy questions, and then you come on with the hard ones, and then they're kind of surprised by it. Or ask a question that's easy for them to answer, and then without them realizing that the next question you can ask questions that whatever way they answer it kind of works in your favor, right? And then the next question kind of goes into it. So I'm not going to go into a lot into cross-examination because it's not a lot of what you're going to do, but just think of the way you're asking the questions. How can you ask it in a way that kind of gets the other side comfortable with you? Or, they might, do you love your children? You love your children. That's an easy question, right? Yes, I love my children. Well, then why did you hit them? Or you might say, do you love your children? Yes. And before you might have asked a question, you might ask that at the beginning, and then you might ask a question like, is hitting a form of love? And they would say no. And then you would like point, make the question, well, you wouldn't say why were you hitting, because I might give them the thing, but then you're kind of like drawing the thing where if you loved your children, you wouldn't be hitting them. There's just ways to ask that. So just think that through when you come to cross-examination questions. With the questions that you're asking for your own client witnesses, you can practice with them, you can prepare, with your clients. I'm going to call out Jen on here. She actually will prepare her clients and she calls it a dress rehearsal. I loved it because it really is. I love that term. I thought it was a great term to use with preparing your client. The client comes in and you're kind of showing them. So preparing your witness and your clients to the place, how is it taking place? Are they going by phone? Is it MS Teams? How does that look? If it was in, a building, you might take them to the building to see it if they're particularly nervous, if they've never been there. If they're meeting, if it's an RTB and they're meeting in your boardroom, you might explain, okay, this is how it's all going to be set up. This is where the phone's going to be. Or for a while, I found they're not like this anymore, but the RTB was making you be in separate rooms from your client because they didn't want you all on the same phone. And they seem to have dropped that. I haven't found that as much lately, but you might have to explain that to your client. You're going to be in one room, I'm going to be in the other. You might explain how you can go on mute and talk to each other, that you can ask for breaks. You can ask to talk often in mediations or in, I will say, or to them, if you need to talk to me privately, just say it and we'll all mute or I'll call you. This is what I'll do to get a hold of you. Just kind of going through that to them. You want to explain exclusion. So in a lot of situations, especially for witnesses, and the RTB does this as well, they're going to exclude the witnesses, right? While other people are talking. And that's just so that if one witness hears what another witness is going to say, they'll change their testimony to match that witness, right? And it really loses the credibility of the witness. And so a lot of tribunals will ask for the witnesses not to be there, to not be able to hear, or to have to leave the room. So you want to prepare the witnesses and the client for that, because it can be quite surprising to them. It might throw them off. What to call a decision maker? Okay, so this can be a really, it might seem like common sense to you, but a lot of these clients, they're not going to know that. Different tribunals and different levels of court are different. I've sat in there as a lawyer. It's a brand new lawyer. And I remember being in one and I was like, oh my goodness, I've, never been before, this type, and it was your worship, it was different than your honor or my lord, my lady. You kind of want to make sure that they know what to call the decision maker if they have to do. When I say ask cross-examination questions too, cross-examine your client, prepare them for that, prepare for them for the questions for the other side, get them used to that. It also really helps you understand what their real evidence is. Sometimes you should always be kind of cross-examine your clients. I will say this to them, I'm just preparing you. I say, hey, I'm going to be like a little bit of the devil's advocate or something along those lines to prepare them for what I'm about to do. But really grill your client. You really need to prepare them for that. And I'm going to go into kind of like what you can tell your clients around those things, but just like I said, preparation, right? You're also going to want to prepare your argument. So I realize this is kind of an oral argument. I know a lot of people just kind of wing it. I don't recommend doing that. I do think you should write these down, have them prepared, then it's in an organized way. You're not all over the place. I do it even for RTV, and I've been practicing for 13 years now. So it's not uncommon, right? I just think it also allows you to write notes around around the comments you've made. You know, and always leave space. And I know I keep saying that. I actually recommend when you're writing an argument, everyone's different, is to not write out full sentences. I write it in point form. And the reason why I do that is that it forces you to not be like this, you know, then you're not like reading just like this the entire time. And when you're reading, not only are you not engaging, even on the phone, people can tell when you're reading, even when it's on the phone, when you're just reading, but it also, your voice changes, right? You become very monotone. You're not emphasizing maybe where you should. It sounds more robotic, even if you are emphasizing. So it is like, I recommend prepare your argument, write it down, go over it, prepare your argument and walk away from it for a while and then come back. That can be very helpful as well. So what to tell the client and witnesses, really, really important. Only answer what is asked. I like that comment before. The more your client talks, the less likely they are to win. This is it. Clients, especially when they're being cross-examined, they will go off on all kinds of tangents. They tell them, slow down, listen to what's going on, only answer the question that's asked. That's all you need to answer. I'll tell them, don't worry about what the other side's going to ask. That's my job, right? You focus on the question that's being asked. Don't try to think 10 questions ahead. Clients will try to do that. That's what I mean. Slow down, listen to the question before you answer it. You can tell your clients, you can always tell them to re-ask the question. You can tell your client that. If you don't hear it, you can say, I didn't hear that. Can you please repeat that? If they don't understand the question, they can ask for the question to be reworded. They can say that I don't understand. I put on there, you can say, I don't know. A lot of clients don't realize that. They can say, I don't know. I don't remember. It's better off that they do that than they guess. I will say to them, don't guess at the answer. Say, I don't know. I don't know. Our memories are notorious. If I told you something happened enough times, your brain will eventually remember that, even if it never happened. If I have a story and I keep telling you, yeah, you and I did this. Yeah, you and I did this. And I tell it enough, you will actually think you did it. Our brains are very, very easily take on new memories. So you don't want your client trying to do that. They say, oh, did you check before you turned? No. And then they keep getting cross-examined. Eventually they'll be like, well, maybe I did, or maybe I didn't. You know what I mean? They waver on that. Said, do you always recommend asking for an oral hearing or an in-person hearing? I think it's going to depend on your client and the tribunal. And I hate to say that some clients do very well on the phone. Some of them do very well over MS Teams, and some do better in person. So I hate to say that, such a lawyer answer to say it depends, but I'm going to say it depends. It really does. It depends on what tribunal you're in. It depends on, a lot of them really give you the option. They kind of tell you right now, especially with COVID, about what's going on. Don't get angry. You got to tell your client and witnesses that. I will say to them, I say, the other side's going to do everything in their power to get you angry. My husband always says 2 people tell the truth, people who are angry and people who are drunk. Those are the 2 people that always tell you the truth. Whether that's true or not. His one of his techniques is to get you angry when he's cross-examining you, because then it's going to come out. TV shows aren't really that accurate, but they even do that on there where you see that, the other side will get them angry and then they reveal everything. People, they don't, when you're angry, you're not slowing down. When you're angry, you're not thinking about what the question was. When you're angry, we've seen it in medical evidence, your frontal cortex, the kind of decision-making part of your brain shuts down. I also say don't get flippant. Don't kind of get annoyed or kind of like sassy, whatever term your client kind of knows. Decision makers don't like that, and it really undermines your credibility. Tell the truth. Clients think they're doing themselves favor by, they might not realize that they're lying, but they kind of try to skirt around the issue. You really want your client and witnesses to tell the truth. And one of the things I do here with my clients is, and it works very effectively in family law, is I would say to them, I just need to know the truth of what happened. I don't care what happened. I've had clients in child protection who said, I don't care if you were getting high last weekend. I don't care if you did cocaine 2 weeks ago, but I need to know it. Because if I know it, I can deal with it. Because the moment you lie to the tribunal, you've lost all credibility. So even though all these other things might be true, now none of them are going to be saying true. You've lost your case. You've lost your case. You get caught in a lie, it's really hard to come by from that. I've actually had many decision makers comment that because the client was willing to tell the truth about X, Y, and Z that worked against them, they believed them about everything else. Decision makers, even if it's detrimental to your client, will believe your client if they're telling the truth. It is better your client admits that they, did cocaine for, let's say it was 2 weeks ago and they did cocaine. It's a child protection file. If I get the client to say that in direct, so if I get them to answer my question about that, and the client's like, well, yeah, but I made sure the children were somewhere else. They weren't with me. They were with their dad. They were safe. By the time they came home, I wasn't high anymore. And it was a slip up. And you know what? I've upped my NA meetings, or I've upped my AA meetings. This is what I'm doing to mitigate that. That's great. The judge loves that. It shows ownership. It shows that you did safely. If it comes out from the other side, do you really think your client's going to have time to talk about how they made sure the kids were safe, that they have done all these other things? So you can take control. I had a file where there was the mom and the dad, and I was only representing the mom, but the mom and the dad and the child protection were on the same side, right? And so it was kind of a weird situation where the other side gave a criminal record to the dad, and because that was kind of the theme, was that nothing had happened for a long time. That was one of our themes. Nothing's happened. Nothing's been involved, and of some police incident. So it's not like a criminal record. It's a police incident, meaning there was some police contact. Police keep track of all that stuff. Not a lot of people realize that. You can actually get police incidences. So every time you call into the police, it's connected to your name, right? Or someone calls about you, it's connected to your name, whether a charge is made or not. And I was able to, because I happened to be cross-examining the dad, I asked him, I said, oh, is this have anything to do with you? It wasn't him. It was someone completely different. I don't know where they got this document about. I dealt with it right there and then, and that document never got entered into evidence. The lawyer on the other side didn't even question him about it. Now, if I hadn't, they would have entered it, even if the client had said, or the client's spouse had said, no, it's not me. They would have entered it because they would have tried to use that as proving that he was lying. But because I dealt with it, right, they didn't even bother questioning him about it. It was done. It was a non-issue. So telling the truth, super important. I cannot emphasize that enough. Now, I mean, that your clients will want to say stuff that doesn't look good for them, that has no relevancy on the case. That's not what I'm talking about. They still want to tell the truth if the question's being asked, but that doesn't mean you need to bring up every single little thing. It just means that you need to deal with kind of those bigger things that can be used against your client. Does anyone have questions about that before I kind of move on, or want to add anything else you might tell clients? I mean, this is kind of a short list, but you guys have lots of experience too. Is there anything you can think of that you think might be really important to tell your client? Just put in the chat or hop on and ask, and I'll give you about a minute to kind of contribute. Oh, say things nice about the landlord. That's true in the RTV. That's a good one. You know, even in family law, we used to do that a lot. If you're just bashing the other side all the time, you lose a lot of your credibility. If you're not willing to acknowledge any good in the other side, your client loses credibility. Same thing where we're talking about your client, you know, not admitting to faults that they have. They also need to admit to things that the other side has done, right? So, I mean, I know I'm using family law, it's just the easiest ones to come up with examples on this for, but like if you know, you refuse to admit that dad does a really good job of, you know, making sure the kids always have clean clothes, you won't even admit that, like the simplest little thing. They're not going to believe you when you say that dad's always getting them to late to school and they're missing half a day of school every day. You know, well, the judge is gonna be like, are they though? Or is it only really like 10 or 12 minutes? You know what I mean? That's another thing, don't exaggerate. When we're saying don't tell the truth, don't exaggerate. Make sure clients are very clear not to exaggerate what's going on. Yeah, I'm gonna get to that. Never interrupt when someone else is speaking, especially phone hearings. That is huge. And that is something you wanna tell your witnesses, is not to interrupt your client. Wait till the question is finished being asked. So when I say slow down, starting to answer, which is an interruption prior to the question being finished, clients do that all the time. And you might say yes to something that you didn't intend. They think they know what the question is, and that's never good. Yeah, this is a really good one. Tell clients when on phone hearings to have their phones on mute until it's their turn to talk. That is a really, really good one. I'm going to add to that, if you're in an in-person one, tell your clients not to make faces. You know, I often forget to tell my clients that one, but I've had times where the decision makers gotten mad because they're like, ugh. And it goes to that credibility end of things, and it just doesn't look good. Submissions from client with swear words every paragraph. He did not want to change wording. Okay, that's funny. That's a hard one, right? If it's like swear words are actually okay in tribunals if you're quoting someone, it's fine. It's a very awkward thing. You know, racial slurs, when you're quoting someone, it's a really hard thing to have to say in court. I always try to preface, you know, I'm sorry, you know, my lord, this is what was said. They usually, you know, they're used to hearing these things, but yeah, it can be really hard telling them not to swear, explaining to them they need to be professional. You can tell them what to wear if it's an in-person one. On the phone, even like the mute in Zoom meetings, we all know that person who forgets to mute, and then you hear all these things coming on and they're off talking to someone. I don't know how many hearings I've been on with lawyers where you can hear them talking to another assistant or another person. You're like, we can hear you. You know, if you are going to be talking confidentially to your client, make sure that they're muting it and they're not there anymore. I'm just going to look at some more of these. You're not obliged to submit evidence just because the client wants you to. Yeah, that's true. You don't have to submit that evidence. You know, one of the reasons why to let go of a client is they were refusing to listen to you. I've had clients insist I ask a certain question or submit some evidence. And I actually remember, and I know I've told this before, I actually told one of my clients, I said, this judge isn't going to like that, and he's going to get mad about that. And because they were pushing back on me, I said, I'm going to do this and you're going to see. Sure enough, brought it up in court and got slammed by the judge. On the break, the client goes, I should have listened to you. Right. And it wasn't something that was big. So I was okay kind of showing them that point because it was a longer trial. But yeah, I mean, that can always be a problem. And you do have an obligation to what's in their best interest. And they say, I tell people I have an obligation to represent their best interest and that I have to make that determination. And if I think someone's going to hurt their case, I can't submit it. And if they really, really insist on it, you can walk away from your client. It's never an easy thing to do, but it's better off than doing it. I mean, I've had a few lately where RTV ones where I ended up having to take them on, and it was a notice to dispute eviction. And then the client moved before the hearing. And then they wanted me to continue with the hearing. And I'm like, I'm not going to a hearing. I mean, this is the only, and they'd be like, oh, but there's all these other issues. I'm like, yes, but that's not what's before the tribunal. I can't go there and argue those, that we have to make a new application for those issues. Client absolutely mad. And I just said, I'm sorry, I can't go to this hearing. You know, here's what you can do if you want to continue, but I can't represent you there because there's nothing to represent, right? It would be improper. I mean, it's such a waste of money and time too. When they insist, unfortunately, you're going to have those clients do most listen, most are good. Another person said, for clients, never say that's a lie or call the other side a liar. That is so true. Yeah, you don't want them doing that. They do that. That's a good one to mention. You know, don't say that. Yeah, don't call the other side a liar. Don't yell out lie. That's the decision maker. You can explain it to them. It's a decision makers. It's them that get to determine whether something's a lie, not you. And when you make those kinds of statements, you're really taking that away from the decision maker, and it's not going to work in your favor. And yeah, I'm going to get into this too, to ignore anything bad the other side says about them. Yeah, that's a really good one. I often tell them that, and that's kind of what I say, and they're going to do everything in their power to make you mad. They're, you know, that really, it almost gives, when you say it that way, when they're like, they're going to do everything in their power to make you mad, it almost makes the client determined not to get mad because now they know that's what they're going to do. So it can be quite helpful. Agree ahead of time who is leading, presenting the case, or who and how to answer the questions. That is one of the things for prepping your client. So when we're talking about prepping your client, going over how it's going to be presented. That's a really good thing. I've had in human rights tribunals, they usually like the complainant to talk. And in mediations to kind of give what happened. And I've said to my client, that's up to you. You know, if you want to do it, you can do it. If you want me to do it, I can do it. I'll say to clients, you know, I'm here in RTV or any tribunal. I'm like, I'm here to talk. If you don't want to talk, that's my job, but just let me know. Right? Some clients, you're going to try to really encourage them to let you be the person that talks. They will be determined to talk. And if it's not going to be in their best interest, then you need to make that clear to them. You need to say, it's better if I do most of the talking. And I'm sure you know what clients I'm talking about. They tend to get angry really quickly. They tend to like yell. I've had clients that just by their mere stature, they tend to be, stronger, bigger men and very intimidating. So if it's an in-person thing, unfortunately, when they get a little worked up, they come across as very intimidating. And so I've had to, it's a hard conversation to have with a client to be like, you're just going to want to keep your voice really low. When you're not angry, you can sound angry, talk soft, you have to have those hard conversations with your clients sometimes. I once had a hearing where the landlord was using the bathroom while on call. It was so gross. Oh no, I'm sure we all have those horrible stories. Make sure you put it on mute. Yeah, that'd be a hard one. Another person, landlords are mostly a collection of personality disorders. I kind of find that with all of our, and I mean, you're going to get all kinds of different scenarios that are kind of going on. I'm just making sure I go through this chat, but my client chose to move forward on his own as he disagreed with my submissions to remove the vulgar language. So that is what I'm saying about that. You can remove yourself. Just give your clients the tools to move on their own. Clients, they're going to insist, right? It's the same way if a client's insisting online, you can't represent them. You have to walk away. So that's something to kind of be prepared about. And I see that people are kind of going, I just want to make sure I'm not missing. So I'm just going to take a second to kind of look through this. Yeah, I usually mute the phone so clients don't get themselves into trouble. I've done that. I had one very recently where the client did not understand what the settlement conference was about, was very angry. The other side was just going after him on all these things that weren't relevant, and very mad that he was on mute and he couldn't yell. And I'm like, the judge is there, like, wait. I mean, it was probably really good that they weren't in person, because I think they would have been held in contempt if they had been in person, which just means that they can get in trouble from the judge. And that's the thing. I often tell my clients to take the high road and to rise above landlord stigma and judgment when landlords raise irrelevant moral arguments. That is really important. That's kind of what's saying, don't take things personal. It's hard for people not to, but to really, I always tell them, you want to be the reasonable one. You want to be the one that I usually use the term reasonable or another term that the client can understand, because you're really going to gain more favor that way. When you come off as not being reasonable, that's when you lose that credibility. And I'll have that conversation. I see more about like handle their own case if they're going to be on their own. Another one said, good point, Jen. Often if you convince your client you need to react to landlord's accusations or untruth, the landlord ends up being the one getting angry or getting off on a tangent. It's actually true. And when you don't like respond to their kind of things, comments that they make, that's often what will happen, is that the other side gets very frustrated with it. I had a person I was asking questions for, and they were getting mad. Why are you asking that question? You don't have a right to ask that question. I didn't respond. I just kept asking the questions, and eventually the judge just got tired and got really angry at them. If I had gotten flippant and angry, the judge wouldn't have done that. I'd rather have the judge angry at them than me, right? You kind of want the decision maker to be frustrated with them more than you. Yeah, and that's a good point to tell them that they have trust in you to highlight the correct evidence, to speak for them if that's what they want. And you can really rely on your experience and point out that you have more experience. And someone said, remember Q-tip, quit taking it personal. Oh, I like that, Q-tip. Oh, I'll use that in the future, Q-tip, quit taking it personally. That's a really hard thing, right? Clients have been through a lot. It's very personal for them. We're more removed from the situation. We can use that for them too. But yeah, just keep in mind, there's a lot to go over. It's really good to kind of come up with your own checklist. Some organizations actually have a piece of paper that you can hand to the client to read. So you go over to them and you hand the client, this is what you do. I've worked at organizations that have had that. It can be very helpful to have a handout for them, things to keep in mind. Another thing to remind them is to not, if they are being, not so much in tribunals, this doesn't happen a lot, and is that they can't talk about their evidence a lot with other people when they're still being questioned, just so that they're aware of that. It might come as a surprise. So writing out your argument, just kind of talking about that. So like I said, write out your argument. I use headings, okay? And so when I say headings is, how we have those kind of issues and those themes? I put that issue on the top in bold. Now, I'm not going to say that, but what it does is if the decision maker will jump around a lot, it allows you to flip to where that is if you need to, right? I use headings for my examinations, questions that I've written out. I use headings for my argument as well. And this isn't something you're going to be handing up. So you don't have to worry about spelling and stuff like that. I mean, it can be helpful, but this is really for you, right? I use point form because it's easier. I might bold something if I want to do emphasis. That's what I'm saying, use numbered paragraphs and pages. So one of the reasons I say that, if you've got to, paragraph 30 of your submissions and then something interrupts it, where to start again. You can flip to that page if you have page numbers. If you happen to have them in front of you and they fall on the floor, you're not scrambling to put them together. A little bit of Murphy's Law can happen when you're doing oral advocacy. It can happen. It will happen at some point. So you just want to have it organized in a way that you can put it, use spaces. Spaces are really handy. Like the other side is making points and you have space in there, you can write underneath that point and add in a new point. Or if you thought of something while you're in the hearing, you'd be like, oh, and you can write it in. So space can be really, really important. Simple is best. I'm going to say my profession is horrible at this. We had a hearing this week and the other side said, oh, it'll be, my submissions will take, 15 minutes and then they take an hour. They probably could have said it in 15 minutes. That really annoys decision makers if you're not keeping it simple. Don't feel like you need to put, throw everything in. You don't. That's why you want to have that preparation ahead of time. So you're really only getting those key points. It's really tempting to talk about everything. It's really tempting to respond to everything the other side has presented. You don't need to. If it's irrelevant, leave it be. You might want to mention it, but if you do it quick. One sentence, that's not true, or something, but you don't need to go elaborate. Don't feel like you have to answer everything. Summarize at the beginning. Remember that theory we were talking about? That's going to be something you use in your argument. You want to put a summary at the beginning. This is why I'm here. This is what I want. If there's a test, then you're going to go into the test. This is the test we need to meet. So we need to show this, this, and this, right? Set that out. Now the judge knows. It's almost like giving the table of contents for your argument, right? That allows the judge to be like, okay, they'll write it down, right? And so they're going to be like, okay, these are the three things. And then they're going to be listening into your submissions that you're giving, your oral argument. They're going to be listening for those things to be met. So it's really helpful. And then you've set out your theory and your theme right there. So the entire time you're talking, they're thinking back to what you kind of wrote out there. Okay, I say start strong, end strong. So if you have some arguments, if you have, let's say you have 4 arguments, 2 are weak and 2 are strong. You're going to start with a strong one and you're going to end with a strong one. You're going to put the weaker ones in the middle. Our brains tend to remember what was first said and what was last said. So what you want to do is one of the first things you say, that's really going to set it out. If you start with something weak, then the judge kind of thinks your whole argument is weak as well. So the decision maker, I should say. So you want to start out strong and end strong. Now, whether you put your strongest at the beginning or the end, that's really going to be on personal preference. It depends on the case and how far off the 2 strong ones are. I might kind of use, if I only had 1 strong one, I might kind of start with that strong one and then reiterate it at the end a little bit, right? Personalize your client and depersonalize the other side. Some people do this, some people don't. What they mean is, if using your client's name, you might say Mr. So-and-so or Miss So-and-so. And then the other side, you might refer to them as the respondent or the claimant. Just watching your language on that to try to make your client seem, I don't want to use the term human, but like the decision maker relates more to your client than the other side. I don't do this a whole lot, but I know a lot of lawyers and other people that do oral advocacy that do. State a point and then elaborate. Remember I was talking about that pyramid? So if you have that test where it's A, B, C that you have to meet. So I might say, this is the case law and it sets out the test we have to meet and we have to show A, B, and C. So when you get to that point, you're going to say, I'm now going to talk about this point A, and you're going to point at that point and then you're going to elaborate. So you're going to go point A, and the courts have said, this is how, or the tribunal has said, this is how point A needs to be pointed out. And here's the evidence that shows, that we've met that kind of the interpretation of that point A, right? So you start with the point and then you work down. It just really helps the decision maker to see, right? You've got what you need, the point, and then you've got, how that point should be interpreted, and then you have the evidence that supports that point. It just makes it really easy for them to do it. And I'm going to say, refer to your evidence. If you don't refer to your evidence, almost every tribunal will not even consider it, right? If you don't talk about it, or you don't have a witness talk about it, or a client talk about it at some point, it's just going to get lost in the shuffle and it won't even be used. You might as well not even put it in. In your submissions, when you come to one of those points, you need to refer to your evidence. Take them to that letter, take them to, that part of the stat deck or what the client said. If it's been like something that's been over several days, you might say the witness said this, just really refer to it, refer back to the evidence and reiterate that in the mind of your decision maker. Just so important. I put whole punch on the right side of the page. Okay. And the reason why I'm going to say this, and I don't know how much you guys can see, but if you punch on the right side, then you have your writing here, and on the other side, most of us write right-handed, so it might not be the same with and I'm going to say this, don't double-side it, because then you can actually use the same paper for writing your notes. So if all your questions are on one side and the blank paper's on the other side, because now you're using the back of those questions, you can ask from that and write your notes on the other side. It can be a really helpful way to kind of organize things. Just a little tip, try it out sometime. It's kind of cool. The other thing is, when you do your notes or your questions, you can actually split your page 2/3, 1/3, and then you have your questions here. And then when things come up from the other side, you can just write in that little paragraph. We often do that just kind of a little tip there. I see someone's made a comment. I think everyone has different strengths as a speaker, and the best way to find yours is to practice. That's true. A lot of this is going to change as your experience. Some people are great at setting the scene, painting a picture, brief storytelling. Others will be more formal. And that's kind of right. And I'm going to get into that. Be yourself, right? The 6 B's, just I'm talking about. Just wanted to point this out. Be slow when you're talking. Give the decision maker time to switch to your evidence. Be polite. Always be polite. Be flexible. Right? Decision makers are going to interrupt you. They're going to ask questions. They're going to want you to jump to different parts of your submissions. Be positive. Okay. Don't be negative. Don't, when people are saying stuff about you, just stick on that. Be positive, be concise. So keep things short. Don't go into it, and be yourself. Right? Everyone's going to do it differently. I was saying my husband, he always says, get people angry and cross-examination to get them telling the truth. My style is more to get them to be my friend. I like start out kind of friendly and easy, and then they let down their guard, and then I kind of hit them with the harder questions, and then they give it to me without realizing it, or they get really angry. Like, we all have our different styles. Some people more elaborate. How do we address decision makers now as we move into not assuming pronouns? See, that's a hard one. I'm looking forward to the day where we don't use my lord, my lady anymore. I don't really have the answer to that. I think we're not there yet. I think we're getting there. Judges, judges, we have to use my lord, my lady. Your honor is really nice. I love your honor because you don't have to worry about anyone's pronouns. I think as we start hearing more people kind of bring up this issue, and we start having decision makers that are more open about the pronouns, we're going to have that. And I agree, people are saying use the person's last name, arbitrator O'Neill, or you can just avoid their name entirely, or just say arbitrator, or you can ask, right? You can ask, how would you like to be referred to? I think we need to normalize that more. How would you like to be referred to? And I think that will make it more. I mean, I've actually had times where I don't even know who on phone where I don't even know who the judge is because they don't actually announce who the judge is. So, it can be quite interesting, especially with telephone conferences now and Zoom. I think I have like one more to kind of go over, and then we can take a quick break, and then we're going to do some breakout sessions. But just tips for you. Know your case inside out. Okay. Know your case inside out. So important. You should know it better than anyone. Sometimes you get given things last minute, so you can't really, but I mean, the more prepared you are, the better it'll be. Give time to the decision maker to write down that test. When I said at the beginning, you're summarizing it, A, B, C. It's harder on the phone. Unfortunately, you can't watch your decision maker. Don't interrupt. We already talked about this. We talked about saying to our clients and the witness, don't interrupt. You yourself need to not interrupt. I've actually told people, and I found this, especially with RTV hearings, that whoever interrupts the most tend to lose because then they get angry. That's kind of my watch the decision maker. If you've been going on for 10 minutes with the decision maker and they haven't written anything down, they don't find it relevant. Move on. They don't care. They're not writing it down. If they're rolling their eyes, they're not buying what you're saying, you might have to switch. I know they really shouldn't be. I've had decision makers throw down a pen because they're just like, oh, we've heard enough of this. They haven't flipped there yet. Or if you've made a really good point, pause, give them time to write it on. Do not respond to personal attacks. So people have already brought this up. Your client shouldn't respond to personal attacks. You shouldn't. Just don't even let it bother you. Just let it go. And answer the questions asked. We said this about our clients, but it's for us too. If a decision maker is asking you a question, you need to answer it. I watch moots for first-year law students. I judge them, and we'll ask them a question, and they'll literally say to us, yeah, I'm going to get to that later. It is a huge turnoff for a decision maker when you're not willing to be flexible, like we said before, and you won't answer the question. You can say, Your Honor, I am going to come to this later on, but I'll answer what you're asking right now. Or you can ask them, I am coming to this next. Would you like me to answer this now? Or would you like me to go there? That's part of be polite. Remember those B's, just so you're aware of that. And I'm just going to make sure, and then we can probably breathe. Okay, just breathe. Always remember this. You can take time to breathe. Tell your client to that. Breathe. Okay, take that time. If they're asked a question, sometimes I tell clients to have a glass of water and they can take a sip of water. Take time to think it through. So I know we've kind of been going for a while. So how about we take a 10-minute break? Then people can, or 15 if Lois, you think that would be better, but it might be a good time for a short break here.
Well, maybe we just round it to 11 a.m.
Okay, 11 a.m. We can come back here. Feel free to take off, get yourself some water, and take time to breathe. So scenario 1, Rex works as a nurse at Pixel Hospital. He's a perfectionist and is often very anxious. Rex's doctor diagnosed Rex with his high-functioning anxiety and advised him he should take time off work. Rex did not want to take time off work. One day, Rex yelled at a patient. When Rex was called into a meeting with management, he told them that he has high-functioning anxiety and his doctor told him to take time off. They then reduced his workload and eventually let him go. So what I'm going to do is a little bit different because I do want to be conscious of the time, but I'm going to ask those first 2 questions. And if someone could please, jump in the chat or whatever to just let us know what your answers would be. So what does the client want to achieve? And what do you think the client would want to achieve? And what would you hope to achieve if you were going to a hearing?
I see in the chat that a couple of groups only did the first 2.
And that's fine. We can always just kind of.
I noted that Rex wants to keep his job and the employer has duty to provide or to accommodate.
And that kind of goes into what those key issues are, right? So what are your key issues here? It's the issue of human rights, and it's the issue of, you're going to have to deal with the fact that there was a yelling at the patient. That's going to be another one of those issues. So what would you say is a law that applies, and what do you think the key legal principles or legal arguments are? So it says when he advised his employer of his disability, right? So that's going to be one of those legal issues is around that disability. Someone wrote maintaining his employment, maintaining a source of income. That is exactly, that's one of the things the client's going to want to achieve is that kind of issue around that. And someone brought up human rights. So that's going to be your law that's going to apply. It's going to be that human rights law. Someone's bringing up human employment issues. So you're going to want to look at employment law. You're going to want to look at human rights. There were no warnings given, not given an opportunity to change behavior, and no accommodations offered. So those are going to be your key points, right? That you're going to want to, great job, guys. That's a really good one. That's what you're going to kind of want to look up. Someone asked, is there union representation? I appreciate these scenarios are simple, so we haven't gotten into a lot of the details. That might be an issue that you need to deal with at all as well. Someone said they looked at the collective agreement. Perfect. And then someone also wrote, what steps did the employer take to work with the employee over this issue? See, and that's the kind of, so those are the key issues that you're going to work in. The one above there, great job, right? So we have all of those things that we need to work on. Do you have evidence to prove each of these points? I mean, the scenario is small, so you're going to look at what kind of evidence. Does anyone have any suggestions about what kind of evidence you might want to look into? We heard about collective agreement. That's going to be one, right? I'd say the employee file. You're going to want to look into that. That might be a piece of evidence that you have. Medical evidence, great. Joyce, that's a great answer to that. Progressive discipline and medical evidence. Yep, that's the kind of evidence that we want to look into that you're going to use to prove those points. So one of the things with the human rights, one of the first things we need to prove in human rights, and I know there's been some submissions around that, do they meet one of those, one of the criteria that results in discrimination? So it's going to be under that disability one, and you have to prove that disability. Then you're going to have to prove that it actually had an adverse effect on them, right? And that the employer, you're going to have to go through those kind of principles. And I know I'm kind of going a little quick here, but does anyone have what the theory or theme of your case might be on this one? So theme, Rex is a nurse with excellent attention to detail, strong ethic, and that the hospital hasn't made use of by accommodating him. Great theme. That would be a great one to go with. Look, stellar employee, just happens to have this disability and they're not willing to accommodate. Look how unreasonable this employer is. You know, that's a great thing that you might do, right? So you're going to list those things out. That would be when you're giving your submissions. You're going to set that test out. You're going to go through each one of those points in your submissions, and you're going to really drive in your kind of theory and your theme. So it's going to move on. Does anyone have anything else they kind of want to add to around these questions, or any other themes they might want to talk about before I move on? I know this is the one you guys worked on the most, so I want to give you some opportunity. So I'm going to go scenario 2, and we'll probably go a little slower on this one. Scenario 2, Rita Book rents a unit in an apartment building. She struggles to walk as she has arthritis. Her daughter, Antique, often gets Rita her groceries and drops them off. Antique has a temper and has yelled at the other tenants many times. The other tenants are scared of Antique and have complained to the landlord. The landlord issued a 1-month notice to end tenancy, and I'm going to say that's for disturbance, right? And Rita Book is devastated. She will never be able to find a place to live with as cheap of rent. She had no idea the other tenants were scared of Antique. So once again, we're going to go through that. So what do you think the client wants to achieve, and what would you want to achieve? Cancel the eviction notice for both, right? So you want to cancel that eviction notice. Rita's been offered that 1-month notice to end tenancy. So you want to make sure, maintain, Yolanda, that's great, maintain her housing. That is going to be something that both of you are really wanting to get out there. How do we maintain her housing? How do we, keep her from losing her home? So that is going to be what both of you want to achieve. So what do you guys think? The client wants to stay in the apartment, right? Those are all those things. That cheap rent, doesn't want it to go up. It's really a housing issue. And this is really, really common, especially nowadays. So what do you think are the key issues? What do you think are the law that applies, and what would be your key legal principles on this? And I know a lot of you deal with RTB. So what do you think are going to be, what law is it? And what do you think are going to be your key legal issues? So people are writing Residential Tenancy Act, right? And Yolanda's right, file a dispute to protect the deadline of filing. First thing you're going to do. One of the things being no warning letter. So that's going to be one of your legal principles that you're going to talk about, because we know that under the RTA principle, when you look at kind of their different, things that they have out there, they want to see that the tenant was given warning and that they had time. You're going to pull out one of their policy guidelines. There's lots of their policy guideline goes through the whole test. Those policy guidelines with the RTB are really good at kind of laying out that test. Another person wrote tenancy agreement. Did it include use of the, the tenant was not notified of the problem. She had no opportunity to address it. We'll rely more on the case decision rather than the RTA, which is true. And I think you would rely quite a bit on those policies. They're not bound, the tribunal isn't bound by those policies, but it doesn't mean you can't use them. And that's something to know about your tribunal and your decision maker. What are they bound to follow? And just because they're not bound to follow about it doesn't mean you can't use it, right? For example, the BC Human Rights Tribunal does not have to consider an Ontario Human Rights Tribunal decision, but it can help guide them, right? People are writing yes, no warning to identify the breach and timeline to correct it. So yes, some arbitrators do have to respect the policy lines. They do have to respect the policy guidelines. I use them all the time. They're quite helpful. They made them harder to find, unfortunately. There was a while there where they were really hard to find, but they are there. They're great to use and kind of put out there. So what evidence do you think you would need to prove each of our kind of those legal things about the no written warning? How would you prove that? Find another source for Rita to get her groceries. There are many news sources of how to help seniors or persons on disability. Yeah, that's a really good way, right? What about the landlord's duty to accommodate Rita's arthritis? So it could end up going to a human rights thing, right? If the landlord was aware that she had arthritis and that she couldn't go, maybe, Antique has a mental health issue that's causing her to deal with it. Now, just be aware that people aren't required to accommodate if they don't know it's there. But yep, that could be another issue that you'd want to deal with. So what kind of evidence do you think you would need? Burden of proof would be on the landlord. That is so important. Always know your burden of proof. And that's kind of a legal concept there. But I've won files by doing that, being like, nope, you're putting the burden on the tenant and it's really on the landlord. Natasha wrote, I would want to see the complaints and letters from the other tenants. So that would be really great. So this is I'm going to say that this would be a great one to have a stat deck for, to have that sworn evidence in. So you might have Rita talk about, about the arthritis. You would have, it also makes kind of the sympathy on your side a little bit too. And explain about Antique and maybe whatever struggles Antique goes. One of the things, we talked about earlier about if there's been a long period of time, and no behaviors happen. One of the things that, Rita might put in there is that she'll agree that she doesn't invite Antique onto the property. Maybe Antique's just showing up at the property and she's not even inviting her. And then why should Rita be responsible for it, right? So putting that into a stat deck would be really good, because this is, you're going to have the evidence of the 1 month notice to end tenancy. You might have, the landlord might, this is actually what I'm going to say the better evidence. This is situations where a landlord might just get letters from the other tenants, right? And then if you have your nice sworn document and the landlord just has these letters from the tenants that are just like signed letters, maybe not even signed, well, then your evidence is going to be stronger than the landlord's as well. But that's the kind of evidence that you might look at. What would be your theory and theme for this case, this scenario? Yeah, so somebody's pointing out here that RTA arbitrators are not allowed to make human rights decisions. You can do both. So that's one of the things we had done a session on. You could be doing the RTB and doing the human rights for the two different issues. The problem with the human rights thing is you really just have to be aware is, did the landlord know that there was, a disability there that they need to accommodate? And that might be part of the conversation that you have. You still want to bring it up at not the human rights portion, but bring up that there was this disability and that's why they were helping out, because it does kind of give you that sympathy factor for your client. Makes your client seem the more reasonable one. They're having, Antique, help out. So the theory is Rita's being evicted for a problem she knew nothing about. Landlord did not inform her of the problem. That is a great one. That is a great theme. It's a great kind of theory. Antique doesn't deliver groceries anymore, so issue is not and not proven, and it's moot. See, that's the kind of thing you want to put out. Great theme, great thing. Look, my client's just a person who's maybe elderly, who has this disability, who's struggling. They have a daughter that's helping them. They didn't even know it was an issue. I mean, it's kind of a great thing to kind of put out there. Yeah, probable that the landlord is pushing her out to raise rent. I've seen people argue that. You can comment it. I wouldn't lean strongly in that unless you have evidence of that. It's better off to kind of let them I would say personally, I probably wouldn't say that directly because you don't have any proof on it. It kind of makes you see a little unreasonable. What you can do is really emphasize about how, if the landlord's already like advertised it before she's even out for higher rent, then you might be able to use it, but you might be able to emphasize the fact that, rent is so high in this area and the tenant's never going to find anything more. Or, I mean, you'd only really want to bring up that you think the landlord's doing that if they've done it to several tenants, and you could show that. It's just like something to be careful about, because sometimes you kind of want to have some basis for what you're saying. Track says ability to show retaliatory eviction is strong. That's true. You just got to be careful. If you're going to say something or kind of emphasize something, you really need to have the evidence to back it up. Even like judges don't like it if you're saying, oh, they're just doing it to get back at me. that's kind of a hard thing to prove, it's better to allude to it and let them come to their own conclusions, right? If you make the landlord seem like a really unreasonable person that only cares about money and you never actually bring up that they're probably doing it, the arbitrators are smart. They're going to make that conclusion on their own. And it's better for the decision maker to make that conclusion than you to give them that conclusion. It's same as a liar. You never call the other side a liar. You just allude to the fact that they have maybe been untruthful in what they've said. You don't use the term liar, but you might point out the inconsistencies in what they have said. Then the decision maker makes that kind of connection there. This is another good theme. Rita is a severely impaired person who requires help and is willing to find other means. She didn't know what was happening, and if she had been warned, she would correct. She's a good tenant who has personally not done anything wrong. That is great. That is a great quick sentence, lays it all out and makes you feel like you really want to sympathize with this decision maker, really want to sympathize with her. Yeah, I'm super impressed, guys. You've done a really good job of kind of coming up with those different things. So I want to give some time for some questions. So I'm just move on to scenario 3. And I know not a lot of you guys were able to kind of get to this one, but I'm sure you can kind of hear it. So Rolly Pipe smokes medical marijuana for her arthritis and severe anxiety. She's lived in the basement suite for 6 years and has smoked marijuana throughout her time there. And no one ever complained about her smoking. Recently, the landlord, Peter Out, decided he does not want Polly smoking anymore as he has had enough of her secondhand smoke. The landlord, Peter Out, has given Polly Pipe several warnings to stop smoking, but Polly refuses since it does not say so in her tenancy agreement. And Peter Out recently gave her a 1-month notice of eviction for smoking in the basement suite. So we're going to go through this again. And one of the reasons why I know it seems repetitive, it's really, if you practice these things, it'll become more second nature to you, right? And if you do in those situations, you don't have a lot of time, it'll become a lot easier for you. But what does the client want to achieve? And what would you hope to achieve in this hearing? So I'm going to say it's same, right? They want to stay in their home. They want to continue smoking in their home, yet maintain their tenancy. That's kind of what they want to do. It's kind of that same resident tenancy that's usually, Jen saying continued peace and quiet enjoyment of her housing, right? For this tenant, it might be extremely important for them to be able to smoke. Maybe they have a reason why they can't go outside and smoke. We just don't know, but that could be one of the things they want to achieve, and it might not be possible. Maybe it's not possible for them to continue to smoke in the unit, but to stay in the home and keep smoking for medical reasons. Yeah, that's kind of what we want to do. And then what would you say are the key issues and what law applies? We've already talked about this, RTA and potentially Human Rights Tribunal 1, but someone said maybe C&D around harassment from landlord around smoking since there's no agreement, right? So what key issues do we see here? Smoking, right? The smoking is the issue. The tenancy agreement, that there's no kind of agreement there that says they can't smoke. You're going to do that key principles. RTB loves it when you go back to the tenancy agreement and you're like, well, wasn't in there, they have their policy guidelines on this. Tenant chose home because it did not prohibit smoking. She has done so for 6 years without complaint. Landlord cannot arbitrarily change the agreement. That is the perfect theory. You've jumped ahead. That is a great theory right there, all in one paragraph. Perfect theory for the whole thing, right? That's what you need to prove, that there was an agreement. There was no agreement that said there was no smoking. Our clients will say, they'll come to us, I'm sure you found this, there's no agreement that says I can't smoke. And then there's like some amendment to their agreement that says they can't smoke that they signed, 3 years after living there, and they signed it. So now it's relevant, that's another thing. Don't trust your clients on those things. Always get the documents and look at them. The more experienced advocates will for sure know this. You get burned a couple of times and a client will tell me that something happened in court and I always confirm it, because clients are emotional when a lot of this stuff is happening too. And they're just not hearing what's going on. So you need to check. Smoking is a recognized disability, and there's probably case law on removing smoking privileges of the process by which it is done. There's a lot of case law around smoking in tenancy that's gone. It's been reviewed, right, judicial reviewed, and it's gone up kind of into the system. So that's great. Look at those case law, right? Look what the test is. What are the courts saying? What is the policy guideline saying? And then, so what's the theory of your case, right? We already had one of those, greatly kind of put out there in your theme, right? Does anyone want to give, you can put another one in there, kind of like what your theme and theory would be. Mine would be like, oh, look at this poor person, you know, with their arthritis, and they probably can't walk out because they have all this arthritis. I'm really going to emphasize, look, you know, there's nothing in the agreement that says this, and this poor person's just like trying to get by. Someone wrote, I'd also say that she's been smoking for 6 years and has not done anything about it, right? Been there for a long time, not even doing anything about it. Clearly it's not a material term, right? There's a whole policy guideline around material terms. So you could go with that theory. If the landlord does not live there, where's the proof of disturbing others' quiet enjoyment, right? Who am I disturbing? Who am I disturbing? Anyone complaining, not really disturbing anyone. Yeah, I mean, and unfortunately a lot of tenants and landlords don't understand the law, right? So any one of those theories can use. You can see where you can come up with different themes and different theories, and you can take it in different directions. The important thing is if you've done all the prep work and you've done that prepare, then you've done it. I'm going to just move on to the next one to just kind of show, because I really think this is important, is just remember, you can do all of these things, and it won't guarantee you a win. But what it will do is mean that you've done your best to advocate for your client, right? It's important to remember, okay, so lawyers that say they never lose are lawyers that never take things to tribunals or court. They settle, right? And that's not always what's best for your client. Take the Human Rights Tribunal. A lot of times putting something forward in the Human Rights Tribunal isn't necessarily about winning. It's giving your client their power back. Sometimes you can go to the tribunal and it's not so much, you know, you're not going to go push a case forward that has no chance of winning, but it's not all about winning. It's giving your client that chance at justice, that chance to tell their story, that chance to fight. You know, when I did family law, that was often the case, you know, especially in child protection, there might be a slim chance that you think of that trial where I said it was a Hail Mary. If I had just settled that trial and just been like, yep, we'll agree to, you know, continue custody order, and they never see their children again, they would never gotten their children back. Sometimes you got to take chances. Losing doesn't mean you did a bad job. Getting a decision against you doesn't mean that you did something wrong. These things are all to help your chances of being successful for sure, and presenting a really good case. But don't beat yourself up, you know, if the decision doesn't come down the way that you want. It happens to all of us, and you can't create the facts. You didn't cause this issue. This was, you know, the tenant and the landlord, or the client and, you know, what the employer, or, you know what I mean? You can only present your case to the best of your abilities. I'm going to say this, you know, I've had to have this said to me so many times, you know, when you're asking questions, you could always ask a different question. You could have always said one more thing. You can sit there and analyze it over and over and over again. There's always something more you could have done or you shouldn't have done. But, you know, you're having to make decisions, split-second decisions. Like I said, you're watching the judge. Sometimes you decide, oh, I'm not going to go down that angle. I can tell the judge isn't buying it. And then later you'll be like, should have I gone down that angle? Just don't feel that you need to worry, you know, about wins and losses. It's not about that. You should be proud of yourself if you've presented the case to the best of your abilities and given your client that chance. So I just wanted to emphasize that. I know particularly with lawyers, that can be a big issue. Someone did write, the eviction is heavy-handed and burden is on landlord to prove it is reasonable. I would let the landlord sink his own case by being unreasonable. That's actually a really good point. And I want to point that out into oral advocacy. If the other side has the burden of proof, don't do it for them. Don't give them the burden of proof. Don't put all the evidence in. You know, they might have provided you with something. If you don't need to submit it for your own case, why would you submit it? Right? You're not going to submit it for the other side. Don't necessarily anticipate what the other side is going to say or do. It's a weird thing in residential tenancy because you do have to submit your evidence before the landlord submits theirs, right? So it's kind of like this, even though the landlord has the burden, it's like a reversal of when the evidence comes in. I really hope one day they change that. I do think it should be changed because often the tenant doesn't even know for sure why they've been evicted. We're assuming why they've been evicted, right? And it might say quiet enjoyment, but what disturbance? Might not even say. The tenant might be like, well, I think this is what it is because it's what they've complained about. So don't, sometimes you're going to wait for the other side. Bylaw is a good example of that. People think, oh, I need to prove I didn't do this bylaw infraction. Well, no, actually the other side has to prove the whole thing. You could offer no evidence and still win. You could say, nope, they didn't prove their side because they have to meet every single element of the charge. So that's just something to keep in mind as well. Someone wrote, find out if the cannabis is prescribed as a medical marijuana by his doctor. Yeah, that would be another one where you might offer medical evidence in there too. We worked hard on this and honestly didn't think we would win, but we were successful for the homeless people in PG. Oh yeah, I saw that new article. Congratulations on the people that were working on that. I think Michelle is the one that kind of wrote that. Share your success stories too when you do have them, right, with each other. Always be, even if it's a loss, sometimes it's a win. You talk about if I in child protection, if I went and I'm trying to get the children back to them, a success might just be getting them visitation rights, right? We talked about what does the client want to achieve and what do you want to achieve? If you've achieved what you wanted to achieve, that's also a success. If the client was going to have to pay $10,000 and the client wanted to pay nothing, and now they're only paying $2,000, that's a huge success. Okay, you might have lost technically at the hearing, but you didn't. You saved your client $8,000. That is a huge win. So try to look at the positive of that. Now I just want to say, feel free to reach out. Don't give my emails to clients directly. I like to know when to give the emails. This is the phone number. You can call in and talk to me. Always feel free to ask questions if you have any kind of questions. I'm always here to kind of help you along or send an email to me. And if anyone has any questions, that is kind of the end, unless Lois has more to say.
Thank you so much. Any other questions, comments?
Yolanda pointed out, is there no details and info in the details, then the notice often gets canceled as there's no details. Sometimes it's minimal details.
See, now you can just sit and read the chat about.
All right.
Yeah, people are very happy. Thank you so much.
Do you have any client advice when clients want to know their chances in trying to say, never tell them they're going to win. Never ever tell your client you're going to win. That's huge. I never tell them. I say, hey, I think there's a strong chance. You never know. A judge or an arbitrator can be different. I never tell them. I might point out the weaknesses. If I'm trying to point out their settlement, I might say, hey, there's always a chance, even if they think they're going to win. There's always a chance you could end up with nothing. But yeah, I should want to mention that never ever tell your client, that they're going to win. You can say strong chance, but I always point, I'm like, you never know the arbitrator. You never know what arbitrator or judge you're going to get. So yeah, thank you very much. Very engaging. You guys know that the presentation is up on Shed, so you can, I like the presentation too. I thought it was very pretty. And that's always nice after a month of training. So thank you so much. And you're 5 minutes ahead of time. So there you go. Nice. Great. Okay. Thank you so much, everyone. Thank you guys. See you all. Nice.